Hey there, investor. You ever wonder how to protect over $1 million worth of real estate assets? Well, today I'm going to be sharing with you a real life case study of how I did just that. I'm going to show you the actual structures that we put in place for this particular client that saved his bacon when a lawsuit struck. All right, let's get started. Okay, so here's the deal. I met with this individual several years ago, and when we sat down to talk about his individual situation, he stated to me that he was really concerned that if he was sued, he was an open book and that someone could get after his assets. And he wanted to tie things down to give himself some protection so he could sleep better at night. So when we started talking about his particular situation, what I found is that he had 3 businesses set up. These were 3 limited liability companies. And each of these LLCs were in his own name. So he was listed as the member, he's listed as the manager of these LLCs. He also had 7 rental properties. So he had 7 rentals, and all of the rentals were also in his own individual name. He had his personal residence here, and guess what? That was in his individual name, and he had a substantial savings account, again, in his individual name. And so he realized he'd seen my videos online, he had read my book, and so he appreciated the fact that he's just a target waiting to get sued. That if somebody were to come after him individually because he's so active in his business and his investing, that if they got a judgment against him, all of these assets could potentially be taken. They could take his business, they could take his real estate. So he wanted to put something in place that made him less of a target, and if they did continue to sue because they didn't know what he had, but they didn't deter him and they wanted to go after him, that they couldn't collect. So here's what we did. All right. We ended up taking each of those businesses, as I showed him, that because his name was on them, I wanted to provide anonymity. I didn't want people to know that he had 3 specific businesses that he's tied to. In fact, I wanted to make sure that no one knew that he was involved with the businesses. So I created 3 Wyoming LLCs, and I changed the owners of all of these existing businesses over to these new Wyoming LLCs. Now you might be wondering, why did I create 3 Wyoming LLCs? Why didn't I put all of the businesses into one Wyoming LLC? Well, see, if I'd set up that type of structure where we had 3 businesses like this, all rolling down into one Wyoming LLC, then anybody that's looking at this business, either wanted to say this business right here, they would know, hey, it's owned by a Wyoming LLC, but this Wyoming LLC owns this business and then it owns this business. So somebody could tie these 3 businesses together. I didn't want them to be able to do that. I wanted the average individual, the attorney, if one of these businesses was being sued, to think, hey, this is the only business that is there that we could potentially go after. I didn't want them to know that there are actually 3 businesses owned by the same individual. So that's why I separated it out. And so if you wonder why I used Wyoming, watch my other videos. Just search my channel for Wyoming. I talk a lot about the anonymity aspects of this. So my client, he can own his Wyoming and control them. But that Wyoming LLC gets listed on each of these business LLCs that he currently had. And the names for each of these Wyoming LLCs were completely different. All right. There was nothing that could tie them together. So if you looked at LLC number 1 here, this business, it went down into here, Greystone Enterprises or Greystone LLC. And then if you looked at number 2 over here, it might say XYZ Investing. And then number 3 over here was Blue Sky Business LLC, something like that. So there wasn't anything that someone say, oh, I see what's going on here. So now we had that set up and we had anonymity for each of those business lines. The second thing I wanted to do was get that real estate protected. So with the real estate, it was, along the similar lines. We took the properties that he owned, all of his investment real estate, we put them into separate limited liability companies like this, and I wrapped all of them inside of one Wyoming LLC. So the reason we did that is I didn't want each of these limited liability companies that own the property now to point back to him. Okay, because instead of the LLC pointing to him, it now points to a Wyoming LLC. And again, for the same reasons over here, we're building anonymity on the real estate side. So all of his investments now were taken out of his name. They're placed into LLCs for asset protection. And those LLCs now were using an anonymity structure Again, no one would know that this business owner is also investing into real estate. So the third thing that we had to look at was his personal residence. And what I did there is I created a trust, a residence trust, where I was listed as the trustee. So I was what we call a nominee trustee. So my name was listed as a trustee on this trust. Let's refer to this trust as the GB Trust. And what we did there is we put Clint Coons, trustee of the GB Trust. And so my client took his personal residence and deeded it into my name. Now, he is the beneficiary of the trust, but a trust, unlike an LLC, isn't recorded anywhere. It's a private document. So no one would see this. All they would see on title, if they ran a title search, is that my client used to own property in his own name. He no longer owns the property. It's now held in this trust. So we got that taken care of. Now we got the house out of his name. And so what we were doing is we're systematically removing his name off of all of his assets. Again, we don't want him to be a target. I want people to think that he doesn't own anything, that if you're going to sue him, there's nothing you can collect, even if you did win. So take the policy limits, if there is insurance policy there, and go away. That's what the purpose is behind this type of planning. Okay, now the last aspect of what we needed to look at was the cash inside of the business, because he tended to accumulate a lot of cash in there for payroll, for supplies, for business expansion. And I brought up the fact that if something were to happen to your business, that cash is going to be what they're going to go after, a creditor would go after. So we need to pull the cash out, not all of it, but a good portion of it. And we need to park it along with your savings in your brokerage account in another Wyoming LLC for asset protection. So we actually created for him another Wyoming LLC down here. And so I would refer to this as his banking LLC, his investing LLC. And inside of here, I put his savings account, his brokerage account went inside of there. And then I instructed him to start pulling cash out of these businesses, distribute it down to this Wyoming LLC, and then move it over to this company here. And so this is where we had a lot of his cash housed inside of this company. Now, to alleviate the concern that he had about having access to the cash, because we drew those reserves down and he did not feel comfortable with that initially, I went back and I put together a line of credit agreement where we agreed from this LLC here to loan each of these businesses up here up to $1 million. So this line of credit stated that this Wyoming LLC down here, number 5, okay, this is LLC number 5 right here, agreed to loan each orange box $1 million apiece. Now, we didn't have $3 million down here. We had about 2, but it didn't matter, okay, because we didn't anticipate loaning $1 million each, but I wanted to put that in place because if we put that loan agreement in place, I explained to him, then we can secure all of the cash that remained inside of these businesses, all of his equipment that he had inside of the businesses, the receivables, if he had any in there, and the actual vehicles that each business had as well. So we dropped this lien against the businesses. And the purpose is to make each business appear as if it's underwater or highly indebted, to discourage creditors. So this was the overall plan that we set up. And I think it's a really good plan, and things are running along just fine. And we structure it in such a way that we didn't add any additional tax returns as well into his life. And then disaster strikes. In one of these businesses up here, there's a claim that's brought by 3 ex-employees. See, in this particular state, they had changed the law and they reclassified independent contractors as employees. And they made the law retroactive going back 2 years. So these 3 prior independent contractors talked to an attorney, got the attorney on board, and they went after him and they sued his business because they're stating they should have been employees and he wasn't paying employment taxes to the IRS, wasn't paying the unemployment taxes to the state, and so that they were injured as a result of this. He should have been doing all this, so they're able to ramp up the penalties of what he was going to owe. Not only did they sue his business, they were able to sue him individually because at the time in which he was running this business, before we got all this structure in place, the employees or the independent contractors knew that he was the one that owned this business. And he was responsible for cutting all the checks. He signed all the checks. So that's something else to keep in mind too. If you're a business owner, do not sign your own checks. Hire someone else to do it. Get a payroll service to take care of that, to cut your checks for you. Because when you're the business owner signing it, it can bring extra liability to you. Long story short, here's what occurred. They went after this business. They got a judgment against this business and him individually for $1.7 million. Got an individual judgment and the business $1.7 million as a result of his not paying these three individuals or not treating them as employees, instead treat them as independent contractors. Now, what I explained to him is it's a good thing that we set up the business the way we did, because the attorneys could have gone potentially on a fishing expedition if they knew we had these other two businesses and sought out other independent contractors / employees and done a discovery request for that. But they didn't know that because they couldn't trace the other two businesses back to him because there was nothing filed anywhere that said, hey, my client owns other businesses as well, because we've done such a great job of protecting his identity. However, he did get this, as I said, entered against him, and he was pretty upset about it. Now, with that $1.7 million judgment entered against him, they were able to bring him into a debtor's exam. And in a debtor's exam, they get to ask you questions about what you own. And he was extremely nervous about going into this exam because now he'd have to disclose everything. They'd be able to find out that he owned these other business entities. They'd find out that those business entities own businesses, they own real estate. And I explained to him, I said, listen, that's the way it works. The reason they're bringing you into the debtor's exam is because they don't know if they can collect or not against you. So they have to find out your assets. I mean, they look at your existing business. Yeah, they got a $1.7 million judgment against it, but you owe this company in Wyoming $1 million from their point of view because we perfected the interest with a UCC-1 filing statement. He said, but I never loaned it $1 million. I said, that's fine. They don't know that. They think that you did. So they're operating under that assumption. That's why they're dragging you in. So he went into this debtor's exam and he disclosed everything that we had set up. He had to. Did we blow his anonymity at that point in time? Yes, we did. But here's what happened. Once he provided all of that information to them and they were able to process it, after about 2.5 hours of going through this, they actually took a break. They turned off the cameras. They left the room because there were 3 attorneys representing these individuals. They came back in the room. They didn't turn the cameras back on, and they looked at him and they said, we understand you've done quite a bit on the asset protection side. Now, we are prepared to make you an offer today of settlement that we will accept $400,000 in settlement of this $1.7 million judgment. Now, why did they do that? Because they stated that they realized he'd created these asset protection plan, and they realized how difficult it would be for them to collect. Now, my client got off the phone, called me up and said, what do I do? Do I take it? I said, no, we don't take that type of number. You shouldn't take that number. I said, they're willing to go lower. That is their opening offer. You buy real estate, you know the way negotiations work. Well, he's able to negotiate a lower number. And I said he's able to negotiate it because he didn't even hire an attorney. He did this all on his own. I'm in the background. I'm the asset protection individual. I didn't represent him in this action, but he would call and ask me questions about it. And he was able to handle it on his own. He was able to walk away from this for much less. This is how you go about creating an asset protection plan and protecting your assets. Listen, I hope no one ever gets sued, but in the event that it does get sued and your information does come out of how you own your assets, that's what's going to force the other side into reaching a settlement with you, because they appreciate the difficulty in trying to dismantle a structure like this. That if it's set up before the harm occurs, they can't use the normal tactics that they use is, oh, this was a fraudulent transfer that you entered into after you knew you were being sued. Sorry, it was already done prior to the lawsuit. So your cause or your claims, what you're going to be limited to as far as recovery, it's been substantially reduced because I don't own assets in my own name anymore. And the way in which I own those assets, you're limited to a charging order. Guys, this is important stuff. You never know when a lawsuit's going to happen. That is why I would encourage you to go out there. If you have assets, set up these types of entities, use structures that provide anonymity to put your assets beyond the reach of potential creditors. I hope you got a lot out of this. If you liked the video, be sure to smash the like button. And if you're not yet a subscriber, what is wrong with you? Now's your time to subscribe. Thank you very much. I look forward to potentially seeing you at one of our upcoming tax and asset protection events. You can see there's a link in the show notes. Click on it. It's totally free. Join, get all your questions answered about tax and asset protection planning for real estate investors.